So today, Andrew and I wanted to give you an update on employment and data protection law and the intersection between data protection and HR issues. The GDPR is now 5 years old. Doesn't time fly? Data protection law continues to evolve, throwing up new challenges, particularly, I think, in relation to the interaction between an employer and employee. We wanted today to talk through some of the key issues that we think arise from data protection law and employment issues at the moment. And in doing that, we are going to talk through some of the enforcement action that the ICO has recently taken to see if we can identify some trends in that enforcement action. We're going to look at data breaches, obviously a key risk area for any organization, particularly I think for an employer looking after lots of employee data. We're going to talk about what to do in the event of a data breach and where the risks lie. Subject access requests, always an issue, always something that will need a bit of consideration when it's received. We're going to try and be quite practical in terms of some of the tips that we can give around dealing with a subject access request. We'll talk through some of the specific problem areas that we as advisors identify. I'm going to talk a little about dealing with subject access requests during the employment tribunal litigation, and also thinking about how you might deal with the subject access request that you've got ongoing when you're agreeing the exit of an employee. So thinking about what might need to go into a settlement agreement. And finally, Andrew's going to talk about what the future might look like. As I've said, data protection law is evolving and it will continue to evolve. And there have been a number of recent developments that Andrew will update you on. And that's what we had to cover. But as I mentioned, we will definitely welcome your questions. So please do put any questions, comments, reflections into the Q&A box, and we will pick up on those at the end of the webinar. So Andrew, I'm going to hand over to you now to talk through some of the recent trends from the ICO's decision making and thoughts around how to avoid a data breach. Please do let me know, Andrew, when you'd like the slides moved on.
Great, thank you very much, Mark. Yeah, so I'm going to kick us off by talking about ICO enforcement, and I'll also look at some recent examples of what the ICO has done, and also some practical tips on how to avoid a data breach. Next slide, please, Mark. So the ICO has a range of enforcement powers available to it. At one end of the scale, it has the power to issue fines at some eye-watering figures. So theoretically, you can be fined up to £17.5 million, or 4% of your worldwide turnover, whichever is higher. But if a breach has happened and the ICO don't consider that it is quite serious, they can, for example, issue an enforcement notice or a reprimand, asking you to improve your practices. And there's an element of naming and shaming. So the ICO will often publish its enforcement action on its website, so sort of the whole world can see what has gone wrong. A recent development that's kind of slipped underneath the radar a bit is the ICO has recently started to publish information apparently about every single self-reported data breach and every single complaint that it's received. So if you dig around on the ICO website for long enough, you'll find this sort of fairly chunky spreadsheet that sort of lists all of these things. So again, that's about the ICO, so think about accountability, maybe just sort of putting in an extra incentive for organizations to sort of to be data protection data protection compliant. So if we look at what the ICO has really focused on, the vast majority of ICO fines have focused on information security breaches and also breaches of ICO, or the privacy regulations around marketing. So if we put sort of marketing to one side for a moment, really the key risk area of data protection remains and always has been around data security. So if you could just choose one area to get right in terms of compliance, I'd be making sure that your systems and processes are secure. And equally, we've seen over the past 10 years a big shift in the sense that it's now far easier for someone to bring a claim for a data protection breach. And again, most of those breaches, most of the claims that we've seen arise from security breaches. So, for example, sharing someone's personal data with the wrong recipient, or not having adequate security in place following a hack. So those sorts of things. And the absolutely crucial thing, fundamental thing, is that if something does go wrong, you've got to be able to demonstrate to the ICO accountability. You've got to be able to demonstrate that you had appropriate measures in place to safeguard against the breach. And the obligation in GDPR is not to have processes that are so robust that a breach is impossible. It's to take appropriate steps to prevent a breach. It's about sort of demonstrating that you took appropriate steps, and that's both appropriate technical measures, such as encryption and network security, and also appropriate procedural measures, for example, staff training and policies. And if you decide to report a breach to the ICO, I think it's really important. You should almost see your breach notification as your opportunity to sort of, to demonstrate you have these things in place and try and get the ICO to close their file as quickly as possible, without them sort of having to go to the trouble of carrying out a formal investigation. Now, there's a bit of a mismatch in the sense that whilst data security is the most important part of data protection, arguably, the data protection law runs to over 1,000 pages, and the section on security runs to less than one side of A4. So it's a bit bizarre, that you've got to, it's so important, but it barely gets a mention in relative terms in data protection law. And that reflects in part that it's principles based. So the purpose of GDPR is not to sort of set out in detail what you should do. Happily, though, there are a number of other resources around data security. And so you've got, for example, the National Cyber Security Centre, which was, this is a government body that was set up in 2014 to provide advice and assistance to UK businesses on cyber risks. And the ICO will lean very heavily on NCSC guidance when deciding, for example, whether to take enforcement action or whether to issue a fine. And if you look at some of the recent ICO fines, you'll find that the ICO goes into quite a lot of detail about whether or not the organisation met NCSC guidance and standards. So definitely one for your IT colleagues to be aware of, if not already, and just be thinking about that guidance. But the NCSC doesn't just cover technical issues. It has, for example, got staff training resources. So it has a basic cybersecurity module for staff. It also has a number of resources to help your organization manage and prevent breaches. For example, it has an early warning service that will apparently tell you if your systems have been compromised. And the more you can do, the more you do to engage with these resources, the less likely that you'll have a breach, and also the more favourable it'll look with the ICO should something go wrong, notwithstanding the measures that you have in place for compliance. We have the next slide, please, Mark. So I just want to be helpful just to look at an example of what not to do, and a recent example where something has gone wrong. So as some of you may be aware, the ICO issued a fine to Interserve last year following a hack of their system, so that their systems were compromised by an external hacker. And the fine was issued in the sum of 4.4 million, so quite a chunky number. And I've set out on the slide here the 7 failings that the ICO identified. And you will, and what sort of strikes me about this is 2 things. First, these are all essential things that all organizations should be thinking about. There's nothing sort of unique or specific to Interserve here. These are all, the basics that sort of, that are equally relevant, whatever sector or whatever business you're in. And also, it just demonstrates that compliance is both about having the technical measures in place and also the process measures, the staff training, and so on. So just sort of very briefly unpacking what the ICO found. So the ICO found that they were running unsupported operating systems. So they were using an out-of-date version of Windows to support their HR platform. So they're using something called iTrent, which I'm sure many of you will be familiar with. But it was supported on an old version of Windows, with the result that over 100,000 employee details were potentially compromised. The ICO also found a lack of endpoint protection. For example, they didn't have up-to-date antivirus and they didn't have all the necessary firewalls in place. The ICO also found that their threat and vulnerability policy wasn't adequate. For example, they couldn't provide evidence of the carried out penetration testing in the past 2 years. There was also a lack of information security training. So of the 2 staff who were exposed to the malicious email, one of them hadn't had training. There were also outdated protocols, and the ICO also found that Interserve's response to the incident was inadequate as well, in that they thought they had caught it. They deleted the malicious software, but even after that had been sorted, the hacker still had access to a compromised account. And then finally, the ICO also found that the account management was too wide, so too many people had administrator level access. So, plenty to reflect on there. And I think this really just demonstrates security is both about sort of, both from your IT team on the technical side, and also from a sort of a people side as well. Make sure that staff, sort of engage with data protection, and they've got the appropriate training and so on. Next slide, please, Mark. Okay, so just to finish off this section, then I've got some sort of tips for avoiding a breach. So make sure that you provide the training as we discussed. I would avoid generic training. So make it sort of specific to people's roles. Make it specific to the sorts of issues that you think might crop up at your organisation. We also recommend sort of providing a baseline training, and then maybe sort of topped up with role-specific training. So, for example, what people in HR need to know might be a bit different to what someone in IT or in marketing needs to know as well. And be creative and be dynamic in how you provide the training. It's not just a question of sort of forcing somebody to sit through a data protection talk for an hour. There are lots of ways to get people engaged in data protection. For example, one of the things that we do at BWV is from time to time, our IT team will send out fake phishing emails and just to see how many of us fall for it. And happily, no one in Mark's team or my team has ever fallen for it. But if they had, that'd be a bit awkward. But it's just a really great way of sort of testing that people were listening during the training and so on. And it's also really important to make sure that this is backed up by appropriate policies. So so you can evidence with the ICO that that you told people what they should and shouldn't do. Again, gone are the days when you could get away with having a policy that sort of regurgitated the sections of the GDPR. you know, and again, make it relevant. So do people work from home, for example? If so, have a section on home working. What are your rules on on sending documents outside of your systems? Make sure it's covered and make sure it's practical. Just be thinking about and assessing the risks, mitigate the risks. As you said, it's not just an IT issue. You know, it's as much about the human side of things as well. Think about whether you need to get certification to something like Cyber Essentials. So Cyber Essentials is a government-backed scheme that sort of helps organizations be cyber compliant, and you can get certification to Cyber Essentials. And again, this will all help. And you can even go a step further and get ISO certification, which is even more sort of rigorous. But you know, it's all good stuff that will sort of make you more compliant, and also counter mitigation should something go wrong. And you know, do use the resources available. Do use the NCSC guidance and ICO resources as well, and make sure that you learn from you learn from mistakes. If something goes wrong, you know, then maybe you might be a good idea to put sort of a gentle reminder in the next staff newsletter about, you know, something about whatever it was that didn't quite go right, just so you can evidence that you've taken steps to learn from whatever might have gone wrong. Okay, have the next slide, please, Mark. So that's everything I wanted to cover off on security. I'm going to hand back to Mark, who's going to talk about subject access requests.
Thank you, thank you, Andrew. So I think looking first of all then at the top tips or initial considerations, I think we can think about. So subject access requests are requests by an individual for a copy of their personal data. Anybody can make a subject access request, but often they are used by employees or, in my experience, former employees as part of a dispute. Sometimes, not always. Subject access requests can be made, and often are made in writing, but they don't have to be. Subject access request process can be triggered by somebody simply saying, "I would like you to provide me with your with the information that I'm entitled to, the personal data that I'm entitled to." There are some initial things that an organization should do when receiving a subject access request. Depending on the requester, it may be appropriate to ask for identification from the individual who is asking for personal data. I mean, this won't always be necessary. If it's an employee sat in front of you asking for their personal data, I don't think it's really necessary to double check they are who they say they are. But there may be circumstances where you receive correspondence, an email or something from a former employee, where you would be well advised, I think, to just double check that the requester is who they say they are. Particularly, an issue might arise where you're receiving a request on somebody else's behalf, whether that's from a solicitor representing them or a family member, also saying that they represent their spouse or siblings or whoever it might be. You do perhaps need to just pause and make sure that you're not going to end up in a position where you're forwarding all of an individual's personal data, responding to a request, and inadvertently sending that information to somebody who is not the data subject. So asking for ID is definitely a useful step to take. It's also sometimes necessary to ask the requester to clarify their request. That is a useful step, particularly in circumstances where the requester asks for a wide range of personal data. Personal data requested, it is perfectly reasonable for an individual to ask for all and any personal data. that their employer or another organization holds about them. But it's also reasonable for the employer to ask the individual to clarify their request, not necessarily to narrow it down, but just to provide some information about the likely locations of the personal data, whether those are email inboxes of certain individuals, such as a manager or colleague, or whether the individual can provide a date range of where the information might be held. The request for clarification can also be useful because it may help with time, the time scales in terms of responding to the request. The general approach is that you have 1 month, effectively 1 calendar month from the receipt of the request to provide the personal data, or we'll talk about extending the time frame in a moment. But asking for clarification effectively will stop the clock from running until that the clarification is provided. It is possible to extend the time frame. There is provision for an extension where a request is a complex request. Now, what is meant by complex isn't always the easiest of things to interpret, but I think it is the case that within an employment context, many requests will be complex, or potentially will be complex, particularly where the request is made in a very general way, or because of the employment relationship, there has been a lot of data created that might include an individual's personal data. So employees will have been in their job for 20, 30 years, and that's going to generate a significant amount of information. That's going to create a significant amount of work for the employer to do in order to respond to the subject access request. If the employer does consider that the request is likely to be complex, then what it's going to need to do is it's going to need to inform the individual of that decision, of that view, and to explain to the individual that as a consequence, it intends to extend the time frame within which it's required to respond by a further 2 months, creating the possibility of a 3-month extension to the original time. Sorry, 3 months from the date when the request was received. The best practice though would be to not wait until that 1 month deadline is about to end before contacting the requester and saying, oh, by the way, you're not going to get your personal data over the next couple of days. Instead, you're going to get it in another 2 months from now. That's not really the right way to frame it. And I think the assessment of whether or not this is a complex request requiring additional time and thus extending the time frame, that assessment should be undertaken at a very early stage. It's probably right that it can be undertaken at an early stage. Considerations of what is the requester looking for, who will need to be asked to search their inboxes, how will we go about that? Those are assessments that can be undertaken at a pretty early stage when the request arrives, in order to notify the individual that this is considered to be a complex request requiring that additional time frame. So once those initial considerations have been taken into account, there is there's obviously the practicalities of preparing the response to the subject access request. The obligation is to undertake a reasonable search for the personal data. And so the starting point, once you've got through the initial considerations, will be thinking about where the personal data requested is located, how you're going to find it. More often than not, this is going to be a question of IT it's a question that the IT team are going to have to engage in, because it's going to require a degree of searches using key terms, using searches of inboxes. And in addition to that, it's likely that you'll need to ask other individuals, perhaps who've been named in the original request, to search their inboxes, to search their Teams communications, to search their WhatsApp messages, to find and locate the personal data that has been requested. So it's probably a two-stage test of getting the IT team to use their tools in order to obtain the personal data, whilst at the same time understanding what individuals themselves hold. Of course, the actual search process will depend entirely upon what the individual is asking for. It may be that there's a relatively discrete set of information, whether it's a specific information on a holiday request or a fitness for work note or something of that nature. But in general, and in my experience, the requests are quite wide-ranging and will require an analysis of inboxes and of a HR file in order to locate that personal data. So once the personal data has been located, the next stage in preparing the response is to consider exemptions, to consider what information, what personal data rather, that has been identified is exempt from disclosure. The legislation, data protection law, identifies certain information that is exempt from disclosure, and therefore entitles you to, as an employer, hold it back, not share it with the individuals, and in certain cases you must hold that information back. There are numerous exemptions, and they're set out on the ICO website. But one of the most obvious ones, one of the ones that I look at frequently, is of course where the personal data is contained in correspondence that is subject to legal privilege. So communication between a client and a lawyer, such as Andrew or I, or anyone at VWV, is exempt from being disclosed. So an email from a HR manager to somebody in the employment law team asking for assistance or advice around managing a grievance or dealing with a disciplinary process involving that individual will, on the face of it, include that individual's personal data, but it is exempt from disclosure. Perhaps the biggest task in responding to a subject access request and thinking about what personal data is exempt is looking at mixed personal data, the personal data that of the requester mixed with the personal data of a third party, often another employee, a colleague, a manager, somebody who reports into that to the requester. That's very common, I think, in an employment law, an employment relationship, that an email may contain a significant amount of third-party personal data. Again, the disclosure of that third-party personal data may be exempt, and the data controller, so an employer, is going to have to carry out a balancing exercise when determining whether or not this exemption will apply or not. The balancing exercise will look at the reasonable, whether it would be reasonable to disclose the requester's personal data, and in doing so disclose the third party's personal data, or whether the balance is on the side of not disclosing that third party personal data. There'll be a number of different factors to that reasonableness test. It may be necessary to obtain the third party's views on the disclosure of their third party, on their own personal data to the requester. It may be that notwithstanding their views, you think it's reasonable nevertheless to share their personal data with the requester. It's one of those areas where it's going to be a case-by-case determination when considering whether the requester's right to their personal data outweighs any reasonable concerns that a third party might have in relation to the disclosure of that data. Once the exemptions have been applied, you'll have to think about how you are providing the personal data to the requester. Generally, the personal data should be provided, well, it's for the data requester to set out the format within which they require the personal data to be provided to them. But generally, you would look to provide it electronically. You're going to need to think about how you can get the personal data to the individual in a way that is doesn't risk a data breach, doesn't risk that personal data being accessed by a third party. So you have to consider perhaps encryption of the files that are sent across to the requester, and or communicating with the requester to understand what their preferences might be to the disclosure of their personal data to them. At the same time as providing the copies of the personal data, there's obligations under data protection law to set out certain information in relation to the way that personal data has been processed. There's a whole series of information which effectively replicates much of what you will have said already in a employee privacy notice about who has had access to that personal data and the reasons for it, the legal basis for processing of the personal data, and also information about how the individual can raise a complaint, can escalate any concern that they may have regarding the way that their personal data is being processed. So you're setting out effectively the route that an individual might have to speak to the ICO or to raise an internal complaint about the way that their personal data has been dealt with. In terms of other points to consider, refusing to respond is, I suppose, an option. There are situations where the request will be onerous, will be administratively complex and time-consuming to deal with. Nevertheless, there's no real opportunity within data protection law to simply refuse to respond, and doing so invites and risks a complaint being made by the requester to the ICO. That complaint is likely then to be investigated by the ICO. The first thing that they will do upon receiving the request is write to the data controller who received the request and didn't action it, to understand why the request wasn't dealt with, to understand what the employer's position might be, and ultimately it can get to a position where it does say that it will require an employer to provide a response to the requester. And whilst I think it's rare in practice for the ICO to issue fines for failing to respond to a subject access request, what failing to respond to a subject access request does do is it puts the employer squarely on the ICO's radar, and I'm sure that would be something that most would prefer not to be in that position. And equally, it if there is a subsequent data breach or another matter that gives rise to a complaint by an individual to the ICO, it's perhaps something that that has already weakened the employer's position going forward. Andrew, not to put you on the spot, but in terms of the law on subject access requests, what does the future look like for those?
Yeah, so as I'll talk about shortly, the data protection law is set to be reformed, and one of the suggested changes is making it easier to be able to refuse to deal with a SAR, a subject access request, where it's clearly unreasonable. So as things stand, you can only refuse to deal with a subject access request if the request is manifestly excessive or manifestly unfounded, and that only really applies in a very narrow sort of situation. So, for example, if you had a case recently where a former employee was making a SAR purely to get material with which to make threatening and defamatory comments about his former colleagues, and we at the time refused that on the basis that it was manifestly unfounded. Equally, we had another matter where somebody would make, like clockwork, would make a SAR on the first day of every month, again just to be a nuisance, and so we got to the point where the client was able to lawfully refuse to engage further. So it's a very, very high threshold before you can refuse to deal with a SAR. One of the changes being introduced by the bill is the ability potentially to refuse vexatious requests, and one of the indicative criteria for a request being vexatious is if it is an abuse of process, and which I think is really quite interesting. I mean, it all depends on how broadly or how narrowly the ICO interpret that. Because you could argue, virtually every SAR ever made is an abuse of process if it's just been used, as a satellite, to implement litigation or a complaint. So going forward, there may be more scope to refuse to deal with requests, that are clearly, where the person clearly has no interest in their data and that is trying to be difficult as part of a wider dispute or complaint.
Yeah, thank you, Andrew, and that's something that I wanted to talk about in this slide. It's just the interplay between subject access requests and employment tribunal litigation. First of all, it needs to be said that the approach is very different in terms of what is disclosable to an individual during litigation. Of course, the disclosure test is that everything in a party to litigation's custody or control is disclosable to the other party where it is relevant. So anything relevant needs to be disclosed in its entirety. It's not about an individual's personal data. It's not about an individual's any document with a name of that individual, the claimant in an employment claim. It's about relevancy. And of course, there's an obligation to disclose documents whether they are helpful for your case or they're helpful for the opponent's case. So that the approach is probably much broader than the right to personal data, albeit, of course, as I've talked about, there are exemptions under data protection law in terms of what needs to be disclosed and what doesn't. There's much fewer exemptions in the disclosure process. Just as I said, a question of relevancy. Privileged, so legally privileged correspondence is still exempt. Without prejudice, communications exempt, so you wouldn't be disclosing your offers to settle as part of the disclosure process in litigation. But there's no exemption around third-party personal data. So if you've got an email that sets out these are the 3 people that we've identified as being at risk of redundancy, you're not generally going through and redacting the names of the 2 other people who you didn't make redundant and simply using the one individual who's brought the claim. That isn't the approach that you would generally take during litigation. There are some circumstances, and if you are concerned that the disclosure of certain information about people who are unrelated to the actual claim may be damaging to them or cause an issue, you can apply to the employment tribunal effectively for permission to make redactions to the documents that will form part of the final hearing bundle. Because, as I say in the final bullet point, employment tribunal hearings are public. They are a public forum, and anybody who's been unlucky enough to be involved in an employment tribunal case will know that journalists, interested third parties do regularly make an appearance, and a copy of the hearing bundle must be made available to them, must be made available to the public. So careful consideration will need to go into what ends up in that bundle, but the general rule is everything that is relevant will need to be included. Dealing with the subject access request during employment litigation can be really complicated, because the subject access request gives rise to an entitlement to disclosure of personal data. It's quite different then to the information that needs to be disclosed as part of the employment tribunal process. But they need to work hand in hand to make sure that contradictory information is not being disclosed. I think the reform that Andrew's mentioned around abuse of process will be really helpful for some of the arguments that can be ventured during a litigation process, because I think perhaps that may give greater opportunity to say, upon receipt of a subject access request that forms part of an ongoing dispute, to say, well, actually no, what you're asking for is information that will be disclosed at the right time, at the relevant time, as ordered by the employment tribunal in relation to the litigation process. We'll have to see how strong those arguments can be put forward once the bill becomes law, and once we get a clearer understanding of how the ICO might treat complaints that arise from that sort of situation. Another particularly interesting area involving subject access requests is thinking about how to manage them as part of an exit. As we've spoken about, often these subject access requests are used as a tool by an employee to help persuade an employer to look more favourably on a settlement proposal, on paying an employee to leave an organisation. If the employer accepts a proposal or agrees to the terms of an exit, it's going to want to think about how that subject access request is being dealt with in those circumstances. My recommendation would be to consider some form of wording in a settlement agreement to ensure that there is an agreement in writing between the requester and the employee and employer, to explain that the subject access request is being withdrawn, to explain that the individual it now accepts that that subject access request will not be responded to, will not be dealt with, they will not receive the personal data that they have requested. I think it's reasonable to include that sort of wording in a settlement agreement, because that wording reflects the understanding of the parties that by receiving the payment, by agreeing to settle claims under a settlement agreement, the individual no longer needs the personal data, and they accept that. But there is an interesting question about whether or not that sort of clause is actually enforceable. Can an employer actually require an individual to withdraw an SAR? Put it another way, if the individual then says, well, I actually have changed my mind and I would like my personal data, please, can the employer validly and reasonably say, no, you've signed away your right to make that SAR? There's no ability in the data protection legislation to require somebody to withdraw a SAR, to to require somebody, in the same way as you can in the employment world, require somebody to waive potential claims, so waive an unfair dismissal claim or a breach of contract claim under a settlement agreement. There's no sort of similar wording in data protection legislation. So in theory, an individual could still challenge, I suppose, the clause in a settlement agreement that they've been made to sign, or asked to sign rather, and try to go behind that and still make a claim. I don't think that these sort of clauses have actually been looked at by the ICO, or the ICO has made a clear determination in relation to whether who's right about that argument. I think there's still a value in requiring somebody to agree to withdraw a subject access request in a settlement agreement, and I think you can be reasonable in your approach, because you can say in the settlement agreement that you're agreeing to withdraw a subject access request, but we're not preventing you from making a future subject access request, as long as that future subject access request relates to personal data that has arisen after the date of this agreement. So in that way, the employer is not saying to the individual, you don't have any right to any of your personal data. We're not trying to say that you can't access your personal data, but we're saying now that this is a clean break. We have agreed that to drop hands, to draw a line under the current dispute, and as part of that, you're agreeing not to take your existing SAR any further. But if new personal data is generated in the future about you, perhaps because you're a customer of the organization, or you go on to study at the organization, whatever it might be, we're not preventing you from seeing that personal data. So I think, in summary, you do think about settlement agreement clauses requiring a withdrawal of an SAR. Be aware that there is a risk in relation to including such clauses and relying on them, and do make sure that those clauses are as reasonable as possible in terms of their scope. I think that's everything we had to say in relation to subject access requests. So, Andrew, over to you in terms of what the future looks like.
That's great. Thank you very much, Mark. And just before we do that, I've just been keeping an eye on the Q&A. And there's just a few questions on SARS that I'll run through. So, are WhatsApp messages sent on personal mobile phones rather than company devices covered under a subject access request? So, assuming it is a private WhatsApp, the answer is you only have to search private devices, private accounts, if you have a good reason to suspect that they hold disclosable information. So if the requester asks you to search people's private phones, you don't have to to do that unless you've got a good reason to suspect that they may contain information in respect of which the company is the controller. Should any data disclosed containing third-party data just have the third party's data redacted as a matter of course, as does not the data subject's right to see the third party's data? So it's as Mark said, it's about that balance, and it's balancing the requester's rights to the information against the rights of the third party. And there isn't a hard and fast rule. So sometimes it will be reasonable to disclose the third party information, and sometimes it won't be. But to be clear, what we're talking about is mixed personal data. If the information is purely about the third party, then it wouldn't be disclosable. So just to give you a quick example, let's say a junior member of staff made a complaint about their line manager to HR. Let's say they said they were sort of rude and abusive, and let's say the employee also said is making me feel very anxious and upset. The bit about the employee feeling anxious and upset, that's that person's personal data. That wouldn't be disclosable in any event. But then the bit about the allegation, that's where you sort of have to do that balancing exercise. Does a work email address, which contains the employee's name as well as the company's, so in effect could identify them, carry the same protection in terms of personal information under GDPR as other personal data? It's an interesting question. So somebody's work email address is their personal data. If you can identify them, which you usually can. And so on paper, it does carry the same level of protection as any other personal data, but GDPR is principles and risk based. So in practice, you wouldn't need to provide the same level of protection to someone's work email address as you would other types of personal data. So, for example, it'd usually be fine to put someone's work email address on the corporate website, but you wouldn't be publishing their health data. As ever, it is context specific. So, for example, the controller, worked in animal testing or worked in industry where people are often subject to harassment, then clearly you would take more steps to safeguard that person's email address than you would to say somebody who who worked for a law firm or a school or a university. Okay, so moving on to the future. So just when everyone got used to data protection or to the GDPR, it's all set to change again with the introduction of the Data Protection and Digital Information Bill. And the bill is perhaps the first piece of data protection legislation ever that has the stated intention of reducing the compliance burden rather than sort of making it, rather than increasing it. And the government has claimed it will boost the economy by up to £4.7 billion over the next 10 years through reducing some of the data protection red tape and also making it easier to use personal data in a way that might sort of turbocharge the economy. For example, it is narrowing the definition of personal data to make it easier to share personal data for research purposes. Essentially, it's going to be easier to argue information is anonymized than it currently is. So we won't have to worry so much about data protection because it's sharing de-identified data for research purposes. So good news for universities and research organizations. So I'm just going to look at some of the key changes mooted by the bill. I should say it's still going through Parliament. There isn't yet a time frame when it'll become law. I expect it'll be this year, but probably towards the end of the year. So it's not going to happen in the next few weeks. Next slide, please, Mark. So one of the key changes is that the role of the data protection officer is going to be scrapped, and it's going to be replaced by an obligation to have a senior responsible individual for data protection compliance. And you'll need a SRI if you're a public authority, or if you do processing that is likely to be a high risk to individuals. Now, the high risk test is the same as the test for whether or not you need to do a data protection impact assessment. So you would have thought that if you need to do DPIAs, then you will need to have an SRI. However, the ICO has suggested that the test might be different. So it seems like there'll be further guidance in due course on which organisations do and don't need to have an SRI. So the SRI must be part of the organisation's senior management, which is defined in the bill as being the individuals who play significant roles in the making of decisions about how the whole or a substantial part of its activities are managed or organised. So the SRI has to be someone senior. So someone who's currently your DPO wouldn't necessarily be able to be the SRI. Having said that, the SRI can delegate their tasks. So I expect in practice, DPOs will continue in the same function in the sense that they're the ones who are managing compliance on a day-to-day basis, but they just might have a different job title. So they might become the data protection lead rather than being the data protection officer. Okay, next slide, please, Mark. So just in terms of just some examples of other changes, other mooted changes, the obligation to carry out a data protection impact assessment is being replaced with an obligation to do an assessment of high-risk processing. And there are different views on whether this is actually a meaningful change. The key difference is that rather than sort of having to do a systematic description of your processing under DPA, you've got to do a summary. So essentially, it's the same thing, but you'll get away with less detail in your risk assessment. And anyone who's seen the ICO's template DPIA knows it runs sort of many pages. So perhaps that might make things a bit easier. The rules on website cookies are being reformed. So you're no longer need to get consent for some analytics or preference cookies. So, as we all know, if you've gone to a website for the first time, you get that annoying pop-up banner and invite you to consent to cookies. So those should disappear from a lot of websites. But as ever, it's heavily caveated. So depending on how you use the cookies, will inform whether you can do away with the cookie banner. You still have to provide opt-out though, so people must still have a means of saying no to cookies, but it's switching from opt-in to opt-out. There's also a new process for complaints. So right now there isn't actually a statutory process in the law to deal with data protection complaints, but that's going to change. So the new laws say that you've got to facilitate complaints by taking steps such as providing a complaint form. And whilst on the face of this may look like an extra obligation, I think this is a good thing because, in my experience, quite often organisations almost get sort of sucked into sort of having sort of endless detailed correspondence with the complainant, and so you try and be helpful, you try and engage with them, you explain your processes, and often all it leads to is sort of a further sort of lengthy email from the complainant. And having this sort of complaint structure set out in legislation might sort of help sort of focus and create a clear sort of pathway to get complaints dealt with appropriately and as quickly as possible. I mean, what's really underpinning this is the ICO are fed up of getting complaints because it costs nothing to complain to the ICO. And just picking up what Mark was talking about, if you've got an employee who's unhappy with something, they're entitled to go to the ICO, even if they don't think they've done anything wrong. They just might do it just as much leverage or to put some pressure on you as part of a wider dispute. And this process is really about sort of making the employee jump through more hoops before they can go to the ICO. So it's really about sort of taking some of the pressure off the ICO, in my view. Next slide, please. Great. Okay, so just finally then, there's also been some changes around international data transfers. So there are extra rules if you share personal data outside of the UK, and the ICO published its long-awaited guidance on this topic late last year. And just by way of reminder, you can only transfer data outside the UK if one of three things applies. If the destination country has an adequacy finding, which means a finding from the UK government that it has adequate data protection. So most, all EU countries, all EEA countries, and certain others such as South Korea, Argentina, Israel have an adequacy finding, meaning that you can export personal data to those countries without taking additional steps for compliance. But some other countries, such as the USA, don't have the benefit of an adequacy decision, at least not yet. And in those circumstances, you need to find a safeguard to make the transfer lawful. And in most cases, the safeguard that you would use would be to contract on the ICO's standard clauses for international data transfers. So you would append the standard clauses that the ICO produced last year to make the transfer lawful. And then finally, there is a very sort of narrow range of exemptions that apply if there's no adequacy or if there's no safeguard For example, if you had an employee working overseas and there was a medical emergency, and the hospital needed to know about any health conditions, you wouldn't be sort of asking them to sign some standard clauses. You just provide the data. So that's provided for in those sorts of situations. So I think probably international transfers are as clear as mud. If you're sort of trying to describe the theories. So just some practical examples. So which of these are international transfers or restricted transfers, and how would you make them compliant? So using a cloud-based HR platform provided by a US company. Well, in this example, I expect you would append the ICO's standard clauses for international transfers to make the transfer compliant. You'll also need to do a transfer risk assessment, and there is a template of that available on the ICO's website. Sharing personal data with a contractor in Germany. Germany is in the EU, obviously, so it's caught by an adequacy finding. So in that example, there's nothing else you need to do to make it compliant. Let's say that you had one of your employees working in Brazil. What do you need to do here? The answer here is nothing, and that's because it's only a restricted transfer if the data is going to a different entity located outside of the UK. So in this example, it isn't actually a restricted transfer. So you don't need to worry about having a safeguard in place or finding an exemption. But of course, you would still need to comply with the other data protection principles in the usual way. For example, around information security, and so on. Okay, next slide, please, Mark. So that was a whistle-stop tour of some recent developments. Just a bit of shameless plugging, if I may. We have our data protection e-learning, which is a online training for staff on data protection. It covers both data protection essentials, so everyday do's and don'ts, plus cyber security. So if you want to sort of help you avoid ending up like Interserve, please do let us know, and we'll be happy to give you a demonstration of how it all works. Next slide, please, Mark. So I think that concludes what we wanted to talk about. And apologies, we have just overrun slightly. We just have a few more questions, which I'm just going to run through. Should the ICO not take such a hard stance on malicious SARs as expected, and it be held that settlement agreement clauses are not binding, what can one do to reduce the risk of these malicious claims? Mark, do you have any thoughts on that?
Well, I mean, if that sort of decision came out to the ICO, then it would all depend on exactly what the ICO has found and is saying it shouldn't be done. And the most compliant thing to do, of course, is to respond to the subject access request, and to respond in a way that is the least administratively complex, the way that an organization can deal with it. I don't know anything more really that we could say in terms of steps to be taken.
Yeah, I think there sometimes comes a point where you just say to the requester, look, we've complied with our obligations, there's nothing more we can add. If you're still unhappy, go to the ICO. And in those sorts of circumstances, you often don't hear from them again. Because the ICO are quite good at spotting unreasonable complainants, in my view. So next question, how will these changes possibly impact the current practice of outsourced DPO services? So I guess if the DPO role is being replaced with the SRI, what will happen to outsourced DPO services? In my view, things shouldn't change massively because, as we discussed, the SRI can still delegate the responsibilities. So in practice, the SRI can still delegate the everyday compliance functions under the supervision to the outsourced DPO service. Next question. WAND is a platform many schools use for pupil data, but WAND have data held in the US. We asked the DFE about the safety of WAND months ago and heard nothing. What would you recommend to make this as safe as possible? When using services like WAND, you've got to do two things. If you just sort of put the US aspect of this to one side, you've got to make sure that your contract with them contains the mandatory provisions required by data protection law, which cover things such as data security, audit rights, and so on. So make sure that your contract is compliant. But you've also got to carry out due diligence on them. So you've got to be sort of looking at, are they actually going to handle your data securely in practice? And it's something that the school must do. It's not something that sort of the DFE can do on the school's behalf, but you should be thinking about, for example, is the data encrypted at transit and at rest? Are they certified to a recognized data security standard? Where is data stored? Is it stored in sort of a recognized cloud storage platform such as Azure or AWS? And what measures are there to keep the data secure? And then in addition, you should make sure that your contract with WAND contains the ICO standard clauses for international transfers as well, and that you've carried out a transfer risk assessment. So there's quite a lot to do when sort of outsourcing, when using sort of third parties to handle some sensitive data, such as information about pupils. Plenty to think about. If we'd always be happy to discuss these things further offline if that would help. And then finally, in terms of transfers internationally between employees in a group company that have separate legal entities in different countries, is this still acceptable? It's a really interesting question. So if you are a UK company and you have employees working at an office in the US of the UK company, that's not an international transfer. But if you are sharing personal data with another legal entity within your group, that does count as an international transfer, and you would therefore need to be thinking about putting a safeguard in place. For example, having a data sharing agreement that incorporates the standard clauses for international transfers. That's